This is Rahul Reddy. We're live here from Houston, Texas. Every Tuesday, we do bring in immigration updates. We take a lot of questions, live questions from 5 p.m. Central Time to 6 p.m. Central Time. Emily, what do we have today to discuss?
Yeah, today we have a new policy memo that was put out by the Immigration Service on February 28th. That we call it the NTA memo, the Notice to Appear memo. So it gives new circumstances when USCIS, who's a benefit granting agency, can actually issue someone a notice to appear in immigration court before a judge in removal or deportation proceedings. We have dealt with this before. It's coming back. So we'll talk about what exactly that involves, what you should be aware of, and what you can do to protect yourself so you don't end up getting a notice of intent to appear, a notice to appear. We're also going to be talking about this new registration requirement the Trump administration announced last week as well, requiring certain people who enter the country to register with them. It's like a very old statute. The last time we dealt with it was right after 9/11 with the NSEERS registration requirement. Haven't had to do that in many, many years. And now all of a sudden they're saying they want people to register. So who has to register? Who's considered to have already registered? How do you do it? What's the new form for that? And then lastly, Trump gave us some interesting plans to create this gold green card, $5 million purchase a green card and you get your green card. And he says he's got it ready to go in 2 weeks. What does that mean? Is that even possible? What does that mean for EB-5? Does that have any impact on the rest of employment-based immigration? So we'll start out with this NTA memo. Have we seen this before from the Trump administration?
Yes, Emily. In 2018, we have seen this memo, but it wasn't been implemented at that point of time. However, now we are seeing it with implementation. They are going to implement it when there is an H-1B extension denial, though. It's kind of vague when we look into the memo whether they're going to do it, whether they're not going to do it. They said that it's going to be only be applicable if the person is a signatory authority. That's what they said. But these memos, they don't interpret with the strict languages. So when I looked into the memo, they said that it has to be the person. Let's say, for example, the H-1B extension is H-1B is expiring in March 15th of 2025, and we get the denial of the extension on March, let's say in April first week. That means that the person is out of status. That's one thing that they said. The other thing they said that the person has to be signatory authority. Is it and or? It looks a little bit confusing to me. So, but the way that they are going to interpret it looks like that if the person get the extension or change of status denied and his existing I-94 expires, they may issue the notice to appear. Now, I just want to explain what is this notice to appear to the people, because not many people who are in employment-based immigration are aware of what is this notice to appear. Is that means that you will be issued a notification that you have to appear in the immigration courts for the deportation proceedings. Now, once this has been issued, though, let's say if your extension gets denied and they issue a notice of intent to notice to appear, though, then the court will issue a master calendar hearing. We have to go and request a master calendar hearing, and that may take about 1.5 years sometimes. Or we can request a voluntary departure. That means that we're going to leave the country with the permission of the prosecutor of the USCIS. Now, once the notice to appear has been issued, people cannot just leave the country. They have to approach an immigration lawyer. They have to go to the they have to approach the immigration court to request for the voluntary departure, and then they can leave the country. Though the consequences are not not that good, and it's going to be very expensive. Normally, when we see that, especially between 2016 and 2020, we have seen a lot of H-1B extension denials, H-4 extension denials. We just used to let them go to their home country and then file a H-1B again when they're in their home country and get them stamped and come back into the United States. But if this notice to appear, it's going to be a very lengthy process, and sometimes it may incur the crossing the 180 days because by the time the lawyer goes and gets a compromise between the prosecution and and us, it may take longer time than 180 days. That may cause for these people to have incur 3-year bar or 10-year bar. Emily, what do you read this memo as? Now you're telling you're reading a little bit differently, though.
Yeah, so I think there's multiple parts to this memo. They kind of list out the different situations where they can issue a notice to appear. And so one section of the memo is basically, they call it aliens not lawfully present in the US. So they're saying that they can issue a notice to appear where, upon issuance of an unfavorable decision, the alien is not lawfully present in the United States. So when is someone not lawfully present? It's after their I-94 has expired. So if you're in any situation where it's a I-129, I-539, I-485, you've requested that benefit, your I-94 has expired, while the applications are pending, you are lawfully present. You're in a period of stay authorized by the Attorney General or POSABAG. So you're totally fine to stay in that situation. The problem comes in when the denial comes after your I-94 has expired. So you were in that POSABAG period of authorized stay after your I-94 expired while the application was pending. But if the application is ultimately denied, that denial puts you out of status. It makes you unlawfully present. And they're saying in that situation, USCIS will issue a notice to appear. So there's a separate section that deals specifically with employment-based petitions, and they list several special circumstances where they will also issue a notice to appear. And under that, I think they're just letting people know that if the beneficiary signed the petition and they are unlawfully in the country and the decision is unfavorable, a denial, then they can also still issue that notice to appear. So I think regardless, it applies to anyone with a 485, 539, I-129, so HL, all of the typical work visa applications and their dependents and the adjustment of status process. If you are after your I-94 expired and relying on that pending application, they could issue a notice to appear. Now, as you said, we had this before, and we definitely saw denials under the previous Trump administration after that memo was issued before, but I never saw any notice to appear for any of our employment-based cases, and I don't think anyone else did either. So I don't know if we're going to be experiencing the same thing this time around, and they have so many other people that they could be issuing notice to appear to. Why are we focusing on the employment-based categories when typically you do follow the law? You'll leave the country on your own. You don't need to end up in deportation. And then you have a way to get back in that situation. So we'll have to see how this is implemented, if it's actually enforced, if we start actually seeing it for employment-based. Under the previous administration, we never actually saw it put into practice for employment-based denials. So what would you say someone should do if they're concerned about this memo? Maybe they followed our advice, they filed the H-1B extension 6 months in advance, but they did it in regular processing, and now they got an RFE. And maybe whatever issues are raised in the RFE, they may not be able to get an approval. And they're going to take their time to respond to the RFE. That's what a lot of attorneys would suggest, is wait as long as possible to buy yourself more time. But if you do that and your I-94 is about to expire, is there anything people should do to avoid being unlawfully present if that H-1B extension actually does get denied?
First thing, Emily, we've been telling from the beginning, even in the Biden administration, in the Obama administration, get the results before your I-94 expires. So if your H-1 is expiring, or H-4 or L-1, L-2 is expiring, let's say in June of 2025, don't wait to get the results until July of 2025. Because if you do so, we were telling previously that you have to leave the country and come back Now, there is an additional thing that not only they have to leave the country, but they should also have, not only they should leave the country, but they will have a problem leaving the country. It's not easy for them to leave the country. So don't take the chance, get the premium processing, get the case adjudicated. If we get a denial by May of 2025 and your H-1B is expiring in June of 2025, you can refile the H-1B extension. When you refile the H-1B extension, you can then at that point of time consider to see as an alternative to apply for a B2 online application, where you can say that just in case of any chance the H1 gets denied, I want to use the B2 application so that I can wrap up my things and go at the same time, stay legally in United States. So they should consider. Now, would I do it immediately though? I probably will wait to see if any of the people are getting the notice to appear at the time when we're getting the denials, when people are getting the denials, rather than trying to voluntarily do, proactively go and apply for B2. I will wait for notice to appear. That's what I'm thinking, Emily.
Yeah, I think we have to wait and see how exactly this gets implemented. If we actually see any of those NTAs, then we can make a judgment call on whether it's a good idea to file kind of a backup application, change of status to B2 before the I-94 expires, as a way to continue that lawful presence to avoid getting the NTA.
Emily,
What about this?
what are these immigration judges, Emily? Are they really independent? Are they really, judge you know what a judge means? The judge is appointed and they cannot be removed. They don't have to give any favorable decision to the government. They are completely independent judicial department. Do you understand that, Emily? What the judge meaning is? In the common law sense, that is how it is. Is that how the immigration judges are?
No, it is not. They're all under the Immigration Service, Department of Justice, and they have their own rules, they have their own processes, and they are certainly swayed by the Trump administration, by whoever's in power. So I think that no, it's not a impartial tribunal. It's not your typical when you go to court, when you file a lawsuit, like we file all these lawsuits for delays and for denials and that sort of thing, you get an impartial judge. Not the same when you're in immigration court, for sure.
They're practically higher level employees of the immigration, not completely independent judiciary system. Well, thanks for letting me know. Now, so what about this alien registration, Emily? Now, does everybody on the H-1B, H-4, L-1, L-2, that typically our people are, they have to all register, or is there a particular segment of people that mostly our customers are legally in United States. If by any chance they are not legal in United States, we already advise them to consult an immigration lawyer so that they can look into the alternative options. But do all these people need to register right now? I know that there is a form that has been created in USCIS, but who are the people who need to register? And if they need to register, where to register them?
Yeah, thankfully, this does not impact many of our clients. Basically, that what they decided is that if you got a visa at a consulate or you were fingerprinted as part of your visa application process at the consulate overseas or at the port of entry, you have been registered. So you're already registered. So our clients who come in on a visa have already been registered. They don't have to go and register again. No action needs to be taken there. The small segment of people that this does actually impact is for kids who entered the US before they were 14 and stayed in the US after they turned 14. They're saying that they want those kids to register within 30 days of their 14th birthday. And they've added this new form. It's already there in My USCIS account. So if you have a My USCIS account, you may be able to see that there. It's the G325R. The G325 is not a new form. We used to use it. We used to have to submit it with 485 applications until they took all the information from the G325 and just added it into the 485 form itself. Now there's a new version of the G325, the G325R. We don't know what exactly is being requested in that form. And it may be too early to take any actions. If you have a kid who's about to turn 14, maybe hold off the next 30 days, see what's happening. Hard to say what is going to happen with this. There may be lawsuits. We're not sure what the point of it all is, other than just fear to scare people, because it really doesn't make any sense why we need to do that for 14-year-old kids. But yeah, stay tuned on that. I don't know. Do you think that people should be doing anything with this registration requirement right now, or just give
I,
it some time?
I think so. They should wait until next week, Emily. Of course, we will have more knowledge by that time. By next Tuesday, we'll give more details with registration, though. But right now, as you pointed out, almost all the people, except those people who are turning 14, as you said, that, our guys, when they go for the visa stamping, they get their biometrics done. When they come into United States, they get their biometrics done. So they're legally in United States. They don't need to register, except these kids who came into United States when they are under 14 years age and they have now turned to be 14, they need to be registered. I would wait until next week until further directions, Emily, as we see how the things proceed, and then and request all these people to register who have turned 14 after coming into United States, Emily.
Yeah, because I mean, obviously, kids have already turned 14 that came in here before they were 14, and this rule didn't exist. So, are they supposed to register late, or does this only apply to people who going forward are going to
I'm going
turn
to
14 and then within 30 days? There's
I
no
I
information out there.
Yeah, I'm going to have them register anyway, Emily. I think so that these people who will register will have to go for biometrics. That's what I'm assuming. Which, if you recall, Emily, in 2000, this was in 2000. You were there in 2000?
Nope, not to
No,
2003.
no. You came in 2003. So this was there in 2000, where they required all the people after September 11th, Emily. 2001, they required all the people to register, even those people who are not legally in United States. They call all the people, particularly belonging to a particular segment of people, though, from those Muslim countries. They told these people to come and register. Even though we took some of the people who are not in legal status, they didn't detain them at that point of time, though. Now that was different, though. But right now, all these kids who are under, above 14 that we are speaking about are legally in United States. They're either an L-1, is there an L2, H4, or F2, or different kinds of visas. So I'm not much worried about these kids, that will they do anything to these kids? I don't think so. Do they really need a lawyer to go with them when they do the biometrics? I don't think so, Emily. Unless there are some issues with their legalities, if they are not in legal status or so, definitely they should contact an immigration lawyer. But otherwise, I don't see any problem whatsoever at all registering them online. The G325 form, it typically has 5 years employment history, 5 years address, and it will ask the social security number, father's name, mother's name, the basic information that it asks. In the employment information, the person can write it as, especially 14-year-old, most of our guys at least are not employed. They can say they have to give 5 years employment history. They have to give the 5 years employment history saying that they're not employed. Unless there is some employment, definitely you need to contact about this 14-year-old kid and then submit it. And I think so they're going to call for the biometrics. That's what I'm thinking, Emily. Emily,
Yeah, I definitely do remember the late registrations that we would have to do for people that didn't register under that old system back in early 2000. So yeah, we'll just have to see how exactly this gets implemented. But as you mentioned, it doesn't seem to be problematic for typical employment-based applicants. So we'll just have to see if they give us any further instructions on how to do it for kids who already turned 14. Last up, we want to talk about this gold card. And, is Trump planning to get rid of EB-5? Can he get rid of EB-5? Is this going to replace it? Is he going to get rid of all the green cards and just sell them? Can he do any of this? What are your thoughts on it?
Emily, if you look into the press notes when he's lively debating about this one, Emily, what practically he is telling is, look, we are giving 1 million green cards a year, which we already know that approximately 1 million green cards are being given every year to the people, though. I mean, anywhere between 750,000 to about 1 million, 1.2 million in some years. Now, out of those 1 million, though, approximately a good number of them will go to family immigration. For example, if a US citizen is married and the dependent will get the spouse will get a green card, and we know that, and some of them is for the green card holders, their spouses will get the green card, though. Now, of course, we know that 140,000 green cards were being allocated for the employment base. Out of the 1 million green cards, only 14% are allocated to the employment base. What he's telling is that instead of giving the green cards for free, let's sell the green cards, is his proposal. And I don't know what he wants to do with the money, but anyway, that he wants to wipe out the national debt with this 5 million per green card. I don't know where he's going to get the customers, but does he mean that he wants to eliminate the entire immigration? Or is it going to be he's going to add this gold card? Is this in addition to the green cards that he's going to do it? He's been keep on telling that you will see that in 2 weeks I'm going to get it. Right now, people are panicked, especially EB5 people that have invested so much money and they have applied for a conditional green card. Some of them may even have the conditional green card too. They're panicked and they're calling me and asking, "Hey, what's going to happen with the EB5? What's going to happen?" I mean, well, if it's EB5 is going to be removed, could they remove the EB1? Could they remove the EB2? Could they remove the EB3? I don't know what this guy. Now, obviously, it's very clear, Emily, that this guy cannot, the Trump administration cannot unilaterally make any moves by himself, because employment-based green card is created by the Congress. For those people, the parliament is called Congress in United States. Now, in India, Congress means it's a particular party, like Republican Party. But in United States, Congress means the parliament. The Congress needs to pass a legislation to either undo the employment immigration. It's not that this gentleman, Trump, can say, "Hey, I'm not going to give the green cards and employment-based visas." He can't just do that. If he could do it, he would have done it, though. But anyway, he can't do that, so he has to go through the Congress. Now, however, when I had a discussion with you today, I was a bit worried what you were speaking, Emily, that typically a legislation of immigration requires the 60 votes in the Senate. And now that means if they want to take over the immigration process, there is a 60 votes. But you are telling me today that it can be included in appropriations. Appropriations means finance bills. In a finance bills, though, it does not require 60 votes. It only requires a simple majority in the Senate and a simple majority in the House, which Republicans control both Senate and House at this point of time. Can you explain more about that, Emily? Now, the 5 million
Yeah.
green card is the illusion at this point of time, but how can they achieve? And if that is
Yeah,
achieved, does it mean that other green cards will be gone?
it's a bit odd that an immigration provision would be done through the budget process. We've kind of gone through this before, where under the Biden administration, they tried to include some immigration provisions in the budget process, and the parliamentarian who's in charge of all the rules for Congress said, no, this particular immigration provision cannot be done through the budget process because it doesn't have the effect on the budget or on the national debt. Now, because Trump is saying these $5 million fees are going to go straight to paying the government's debt, could he say that this particular provision can be included in the budget reconciliation process, so that we don't need the majority, that we just need the simple majority of the 51 votes. So I think and that would maybe make sense if that's the plan based on the timing. If he's saying we can get this done in 2 weeks, because they're going through that process right now. I think our current budget expires March 15th, if I recall. So we're coming up to the deadline for when they need to be passing the next budget. So it's possible that they might try to include it there, because otherwise there's just no other way to do it without going through the normal legislative process and getting the 60 votes to break the filibuster. Now, can he eliminate EB-5 through the budget process? Can he eliminate employment-based green cards from the budget process and replace them with this gold card? I don't think so, because those other changes he would be making have nothing to do with the national debt, with the actual budget of the country. It's not financial. So I don't think he could use the same process to get rid of parts of our immigration system. And this might be the only area where he could potentially add a new green card category, because it's meant to go straight to the national debt. So definitely interesting times, but I think most of our employment-based system is safe from being eliminated by Trump. We'll just have to see if this new gold card becomes an option.
Yeah, keep watching, guys. We will update any things that you need action at this point of time. For those people for registration, I already got questions from RKV from YouTube. The child has turned 14 last year. Yeah, just tune in until next week, though. We'll give you further directions on to whether or not to register. But if you want to go ahead to the My USCIS account and try to fill it as much information as possible, that the G325R, you can fill it and keep it ready, and then we'll give instructions next week what to do on that. Let's go to questions, Emily. Ajitya Joshi has this question from YouTube is, are you seeing double interviews for the people who are applying for the visa stamping in there? Yes, they have increased a lot. There'll be first interview and they'll be called for another interview. And sometimes they're calling into a small room to go through grilling session. Yes, we are seeing double interviews more frequently right now than before.
I Love Trump says, I'm on an L-1 visa with company A and took a part-time job with company B using my green card EAD. I filed an I-9 with that company. Do I need to file a new I-9 with company A? No, you don't. So the I-9 re-verification process is only when your current employment authorization expires. So when your L-1 is expiring, company A will come back to you and say, hey, I need new proof of employment authorization. Hopefully by then you'll have your green card. If not, you can, if they've renewed your L-1, you'll have that. Otherwise, you would provide that EAD at that time. But they don't re-verify unless your current employment authorization is expiring. However, just be aware that by using that green card EAD, you're no longer maintaining your L-1 status, because your L-1 only allows you to work for your L-1 company. You can't be both in L-1 and using the green card EAD at the same time. The L-1 status goes away when you do that.
Question from Kirtana Anil from Facebook. She has acted in 8 films and 5 television series. Is she qualified for EB1 category? For the EB1 category, it's not that you acted in 8 films or you acted in 5 series. It's, have you earned any awards though? What is your compensation? Is it very high or is it just normal? Have you got any national awards or state awards? Practically, it's not even state awards, so this is more about national and international awards. So if you have earned any national awards or international awards, that probably can push you into EB1 category. Just by acting itself will not automatically qualify into it. Sanjay has this question. He's considering, after filing the 485 and after 180 days, can he move to company B? What if the denials comes in I-485 application? Can company B file a motion to reopen or appeal the decision? Now, here is the thing, Sanjay. Once it's 180 days has passed since the time your I-485 has been pending, you will be you are the boss of the I-485. It's not the company that filed the 485. It's not the company that you're going to join. So technically, if there is any RFE, you could answer by yourself, or you can take the help of the employer. And sometimes they will ask you to have an employer to sign an I-485J and give it to you. But you are the boss. It's not unlike H-1B, I-140, who is the boss there, at least EB2 and EB3, I-140 in the H-1B, it is the employer who's the boss. When it comes to the I-485, you are the boss. You can control it. You can choose a lawyer. You can change the lawyer. You can respond to the RFE. You can appeal it. You don't need an employer to appeal the decision.
Renalva says, my family's H-4 extension was filed after their visas expired, but before the I-94 expired. Does this impact their case approval? So you have to understand there are lots of different moving parts with immigration when it comes to expiration dates, and there's different documents, but the I-94 is the one that controls when your status expired. So when you say their visa expired, I assume you're talking about the visa that is stamped in their passport that has their picture on it. It was issued by the consulate outside the US. You only need a visa to be valid on the day you're coming into the US. You show that in your passport to the CBP officer. Then they give you an I-94 that tells you how long you're allowed to stay. That I-94 is online on the CBP website. And then maybe after that, you filed an extension with USCIS. Now you have a new I-94. When that extension gets approved, that comes on paper on the I-797 approval notice. But it's always the I-94 that controls, not the visa stamp. The visa stamp is only a travel document. It has nothing to do with your status. So if you're saying that their visa stamp expired while they were staying in the US, but their I-94 has not yet expired, and you timely filed before the I-94 expired, then the visa stamp is completely irrelevant. So it has no impact.
Sarvesh has this question from YouTube. Do you see that the current government is going to go to 60 days POM adjudication? No. Why are you laughing, Emily?
Definitely
No.
not. They have zero plans. We even sued them about it, and they could care less about perm processing times.
Yeah, it's very, I
No
don't,
care at
I
all.
don't think so that this government wants to cut down. Right now, for the POM process, there are adjudicating cases that are filed in October of 2023, not 24, guys, October of 2023. One good thing about is that if the labor application is pending for more than 1 year, you can apply for the 1 year extension. You don't have an option at all. Emily, what are the updates of the NIW right now under Trump administration? They made it more stricter.
I think, yeah, I think we're seeing more and more requests for evidence, delays, premium processing. They're blowing past those deadlines. So I think that it's definitely more difficult to get those approved now, but still possible.
Question from
Um,
Krishna Chaitanya. Is it okay to travel to Puerto Rico currently on H-1B and H-4? Absolutely not a problem to travel to Puerto Rico. Puerto Rico is a part of United States, not a foreign country. And as long as your flight is going from United States to Puerto Rico directly, except if there are some flights that go to Mexico City and then from there they fly to Puerto Rico, no, then you probably may have to consider other options. But yeah, if you're just directly flying to Puerto Rico and coming back, not a problem. But make sure that you carry the non-immigrant visa stuff there when you go, because it's a small island and they sometimes ask for immigration status who's there, because there are very nearby neighboring countries where people can swim from their country to Puerto Rico. So they are asking the status there. So please make sure that you carry the documents there, not just the driving license. Emily, do you recommend everybody to carry the non-immigrant visa statuses right now?
I would, maybe not the original, but take a picture of it, have it in your phone, have it available just in case, or keep a copy with you. I do think that's a good idea in the current environment. Arun says, I have an H-1B with an approved I-140. My spouse has an H-4 EAD. If I switch to B-1, B-2 after a layoff, can my spouse continue working? No. Your spouse is only, even though the EAD card is not expired, that EAD is only valid when they're maintaining H-4 status, and they're only maintaining H-4 status if you're maintaining H-1B status. So they actually also need to file a change of status to B2 if you're planning to do that. Otherwise, you'll be putting them out of status if you don't file
Ghana Party
anything.
has this question. I'm on H-1B. Do I need to go to office as a mandatory? No, that's only for the government employees. It's mandatory for them to go. If you're an H-1B, it's up to you and your employer, as long as the LCA is allowing you to work from your home, it's perfectly all right. And this is very important though. If you change the home, let's say if your LCA is and your apartment is in Florida, and now you're moving to Dallas, you need an amendment. You need an amendment before you move to Dallas, not after you move to Dallas. Even though you are moving from one apartment to another apartment, even though you're not going to the work location at all, you need an amendment when you change the physical location. If you move beyond the MSA, you need an amendment.
Mindscope says, has USCIS paused I-140 premium processing? My petition's been pending since January 21st. No, all of them are still available. EB2, EB3, kind of perm-based I-140s, no issues with premium processing there. I've been getting approvals, but we are seeing some cases for NIW and EB1A where we file in premium and they blow back past that deadline and then later issue a request for evidence. And so we're not filing in premium for those types of cases, but regular H-1B, no problem. L-1, no problem. Regular perm-based I-140s premium is definitely still fine.
What is an MSA, Metropolitan Statistical Area? But in general, though, if you are within 30 miles of the LCA location, let's say you move within, let's say you are from one location and the other location is within 30 miles, you're perfectly all right. Now, between 30 and 60, lawyers need to judge whether it's going to be good or not. Beyond 60 miles, definitely needs an amendment, though.
Baltic says, what were the common reasons for NTAs that you guys encountered back in 2018? There must be a stringent reason why they issue an NTA. We never encountered any for our employment-based clients, even if we had a denial. So as I said, they did not really implement the NTA memo, even though it's the exact same memo that they've done now. So as of this moment, I'm not, super fearful of it. Definitely something to watch out for, and that might change. But under the memo, they don't have to have a reason. The only reason to issue an NTA is you've been denied and you are unlawfully present because of that denial. We can issue an NTA. That by itself is enough reason. We never actually saw it happen
Let me ask you
before.
this question to you, though. Do you see a difference in the Trump administration 1.0 to 2.0? And if so, in the immigration wise, is it more stricter or are they more lenient?
Definite differences. Everything is happening much faster than before. The changes, like this NTA memo, didn't come out until like his second, third year of being in office. So things are happening a lot faster and definitely stricter. Now, all of a sudden, we have they're changing the I-485 form. No advance notice. They're adding social media to various immigration forms here in the US, which up until now, under the prior Trump administration, those were only on the DS-160 when you were applying for the visa. So yeah, they're definitely more strict on things, moving a lot faster than before and looking for more ways to deny visas, to deny people entry, to deny applications filed with USCIS.
Couple of questions with regards to birthright citizenship. It still is paused right now. Those people whose kids are born after February 19th, We strongly recommend that you get the birth certificate, go and apply for the passport. And if there's an expedited, I think so, there is some expedited process also. You can do it where you can pay extra money for the post office. Do it though. Please try to get it as soon as possible though. Don't wait until what the court order gives in. We don't know what if the court order comes in this way, that way. It may be very, I mean, if they may not, sometimes what if the court order comes in saying that if you already took the passport, then they won't take it back. So definitely, we strongly recommend those people who are getting born after February 19th to get the birth certificate and get their passport ASAP though. What about the implementation of the mandatory 485 interviews though? We haven't not seen it yet, but there is a good likelihood that they may opt for 485 mandatory. Everybody will be interviewed. Will this cause a problem? Will this cause any prejudiced movements? We don't think so. What do you say, Emily? What if there is everybody has to interview and they don't have enough resources? Will the prejudice move forward?
No, I mean, I don't see how it could, because those cases are still going to be pending. Those green cards just get wasted. That's what happened before. Partly due to COVID, but also because of these mandatory interview requirements, and everything was just taking longer. So if those cases remain on the books, they can't move
But
the
let me
date
let me let
forward.
me put it
It's
forward
definitely
this
not a
other way,
good thing.
Emily. It was what if the family also need to be interviewed? Is that right? The family also based in a lot of the cases that I am filing the U.S. citizenship, a good number of U.S. citizenship, getting married, and the case is very clear. They're just sometimes approving without anything, and especially for the parents when I'm filing the application, Emily, 90% of them, they don't get interviewed. They just get the green card. Now, if they have to interview these people, of course, the ones that I spoke were immediate relatives, but there are other cases too. Now, if all these cases were to be interviewed, could there be a backlog? Now, for the family-based,
Of family-based
yeah,
cases
yeah,
to create more
right, right.
employment-based cases. I mean, yeah, but then they still can't
Okay.
process them. So they'll just
Yeah.
go to waste. It's not gonna help anybody. And I think the percentage of 485s in the family-based category is quite a bit lower compared to consular processing. And it's the consular processing that created that movement in October
A-
2020.
Yeah,
So I
and
don't
also
I don't
and
see the
also all
interview.
these preference immigration petitions, family immigration petitions, they are interviewed already though. 98% of them are interviewed anyway. So nothing new about it. So I'm not expecting any priority date movements because of the backlog. In fact, it may even be a more backlog for the Indian nationals because if they waste more green cards, it's not going to be good for Indian nationals.
Chirag says, can you register an LLC while you're employed under an H-1B visa? Maybe. So you can own a business while you're on H-1B, just like you can own Microsoft stock. You go out and purchase it. You go out and become a member of the LLC of the company. But it has to be passive ownership unless your H-1B is transferred to the company under this new entrepreneur H-1B rule that allows you to get an H-1B to work for your company while you're also owning the company. So up until you have actual work authorization that allows you to work for that company, you need to be very careful about what your actions are and make sure all you're doing is passive ownership of the company, not taking any active role in the company. And even with that, USCIS officers do not understand this situation. We see time and again when you finally get to your 485 interview, they say, wait, I see, because they can look this stuff up. I mean, it's public information. They look up your name on the Secretary of State website and they see you're listed as a director of an LLC or as a company. Whoa, you're working without authorization because you are listed as an owner of this company. they don't understand that there's a difference between owning a company and working for a company, and you can own it without working for it. So people's 485s have definitely gotten into trouble because of that, even when they did not play an active role. So just be very careful with that. But technically, you can own a company passively, just like you can own stock in
Question
Microsoft.
with regards to H1, H4, and EADs, guys. A couple of questions are coming, especially from Jyotir Kumar and also from Pravya, Amazon. Um, we still recommend people to file H1, H4, and EAD together. We are still seeing the adjudication. Good number of them are getting approved together, H1, H4, and EAD together. But at least 15 to 20% of them are not getting approved. And as you already know, that the Idukki settlement ended in January 19th of 2025. So when the new administration come in, this court case doesn't exist. So they're not under any obligation to approve H1, H4, and EAD together. But we strongly recommend people to file it together instead of separately. Pravya was asking question that can H4 and EAD extension be filed with the receipt notice of the H-1B? Absolutely, you can. You don't have to wait for the H-1B approval. You can file with the receipt notice. No problem with it.
Kalai says, I'm on an H-1B with an approved I-140 and I'm planning to switch employers. Do I also need to file for the H-4 along with the H-1B transfer? Technically, no, but we do recommend it. The reason, assuming that the H-4 is still valid for some time. So if you're filing a transfer, maybe you just got your H-1B extension approved a year ago, your H-1B is still valid for the next 2 years. Your spouse's H-4 is still valid for the next 2 years. There's nothing requiring your spouse to file an H-4 extension 2 years in advance. We do it anyways so that everybody will have the same end date, because time and time again, if you end up with different end dates, you'll forget somebody's end date and forget to file the extension. So for that reason, every time we file a transfer, if someone has an H-4 spouse, we recommend filing the H-4 unless they have travel plans or something
Very
like
good
that.
question from Praneeth from YouTube. Does USCIS allow to file the change of status from F1 to H4 plus EAD together at the same time? And if so, what's the processing time? The answer is yes. You can file H4 plus EAD from F1. So it will be change of status from F1 to H4 plus EAD at the same time. Absolutely not a problem. And will H4 and EAD be adjudicated together? The answer is a good number of times. I would say about 95% of the time or 92% of the time, the H4 and EAD will be approved on the same day. And typical questions that crop out is that what's the processing time? Anywhere between 5 months to about 9 months is the processing time. And there are other questions people ask, which you didn't ask, but I'll ask on behalf of you, that if the H4 and EAD has been filed, do you have to stop working if you have an OPT or STEM extension when the H4 is pending? You don't have to stop working. You can continue working until the H4 is adjudicated. Once the H4 is adjudicated, if the EAD has been approved at the same time, then you don't have a problem. But in case those 5 to 7% or 8% of the cases where the H4 is approved and the EAD is not approved, you have to stop working at that point of time.
It says, my son has his passport expiring August 2025, but his visa is good till July 2026. But when he entered last time, because of the passport, he was only given the I-94 till August 2025. Does the local CBP office extend the I-94? No, they don't. The local CBP offices will correct errors on the I-94, but this is not considered an error because they properly, in their mind, gave the I-94 till the date the passport expires. Luckily, in your case, you're aware of it before the I-94 expires, because now to extend that I-94, your son needs the new passport and can either travel using the visa that's in the old expired passport, because that has not expired, or can file an extension with USCIS. So there's ways to fix it, but going to the local CBP office is definitely not one of them.
And one thing, guys, Don't go to CBP office unless you speak with a competent and experienced immigration lawyer. And don't go to Dallas CBP office, period. I mean, those people who went to Dallas CBP office have so much bad experience. People there behave so rudely, so badly. It is horrible experience for everybody that I know who have went to Dallas CBP office. Now, there are, if sometimes when you are not in status, you are walking into CBP office, they may just detain you and put in proceedings, which is not advisable. So just don't randomly make an appointment, call the CBP office, or just going to CBP office. Don't do that unless you speak with a competent immigration lawyer.
Swapna says, does USCIS decline EAD and AP extension applications if we already got them through an EB3 downgrade or through spouse? Sometimes there is no consistency to it. I have many people that have multiple 485s and they got multiple EADs and APs through those 485s. I have others that have multiple 485s, and when they filed the extension of one, they said, because we gave you this other one, you don't need it anymore, and they denied it. Others, they just administratively closing it, saying that you've already gotten that benefit. So I think it's still worth filing them, but just know that, so that you'll have it, but just know that they might deny
What
it.
happened to the advisory committee recommendation to give EAD for an approved I-140? Will we see the light? Not in this administration. This administration is now controlled by Stephen Miller, and he would not like to see the people who have an I-140 approval getting an EAD. Also, question with regards to removal of the per country limit. It's off the table right now. We don't know when it's going to come in, if it's going to come in. Very unlikely in this administration to come in and get it passed, though.
S. Roy 123 says, is it advisable to travel to Mexico now on the EAD AP? We're not seeing any issues with that. The AP entry is fine. EAD is not a travel document. That's just your work authorization. But if you have the EAD card with the AP noted on it, then yes, you can use that for travel. We're not seeing issues with that. No issues with travel to Mexico in that situation.
Question from Vincent. Is it true that when we move from H-1B to B2, you only get 30 days to stay instead of 6 months? Not true, Vincent. This is for those people who are getting laid off on H-1B and L2. And if you want to stay in this country, either to look for another jobs or you want to pack your bags and leave, you want to take times, you can apply for the B2. And you have, if your I-94 is still valid, let's say, for example, you got laid off on March 1st and your H-1B of 2025 and your H-1B is valid until December 2025, you have until about May 1st or so to file for the B2. And you can request from May 1st to 6 months from that period of time, which I think so is going to be September, October, November. Until November, you can stay. So even though you got laid off in March 1st, you can stay to 60 days plus 6 months. So that gives approximately 8 months to find a different job. And then you could be looking, according to the USCIS website, they have advised that if you want to look for the jobs, you can, especially when you are transiting, when you lost the job, and you can apply for a B2, look for a job. And once you get a job, this is the good point there, is that you can move back to H-1B without leaving the country. You move from H-1B to B2 and B2 to H-1B without moving outside the country. We have done that several times, have no issues at all. People can file the B2 application online and then avail the services.
It says, are there more denials in new L-1B filings? My spouse is planning to file an L-1. If the H-1 doesn't go through, I'm just skeptical about everything now. We did see that previously under the Trump administration. I have not noticed a change yet. I do expect it to come. So definitely more documentation is going to be needed, assuming this is an individual filing with USCIS. It needs to have corroborating evidence of the specialized knowledge and why that particular position in the foreign country requires specialized knowledge and why the U.S. job requires specialized knowledge.
Um, uh, SS is asking the question, do we help EB1A applications and EB2 national interest waiver? Yes, we do, but the proper persons in our office is not going to be Rahul and Emily. It is going to be Kareem Jivani, and we have Jackie G. These are the two people, and you can also contact Rebecca Chen in our office for these things. I would strongly recommend Kareem and Jackie in our office, and you can go to our website. When you do make an appointment, though, please make sure that you give them a detailed resume and point out any web links that lists out, especially Google Scholar link, that list out any of the publications that you may have. It's going to be easy for them to evaluate to see if you're going to fit into, if you don't fit, what are the things what you need to take steps so that you can get fit into EB1 at a later date.
Vishal says, I transferred my H-1B and I'm now with employer B, but I have a valid visa stamp till December from employer A, my previous company. If I'm visiting India, do I need to get the stamped visa for my current new employer B? No, you do not, as long as you'll be returning to the US before December 2025 when your old visa stamp with your old employer expires. So the H-1B stamp remains valid regardless of what company's name is on it, as long as you have a valid I-797 approval notice and a valid I-94. You can use that stamp.
EB5 is still available, Mr. Garapati Sri Kiran. Kalki, your question for H-1B transfer is not approved. So he's planning to move from company A to company B. Company B transfer gets denied. His question is, can he continue with company A? His H-1B is still valid. The answer is yes. Even though the company B change of status has been denied, company has been denied, even though it is denied for company B, you can continue with company A. Absolutely not a problem. Garapati Srikaran has this question. Do you guys service other than Houstonians? Absolutely. We have less than 5% or 10% clients from Houston. The rest of the clients are elsewhere, though. Not just us as immigration lawyers. Most of the immigration lawyers do serve nationwide, though. It doesn't require that you have to be in Houston. Your employer does not need to be in Houston. And any of the filings need not to be in Houston at all. We have very less number of, I would say about 10% of our clients are from Houston. The rest of them are not.
Tushar says, you recommend to go with premium processing as soon as possible for an L-1B individual visa extension if the employer is applying in the U.S. itself. Yes, I definitely do. For any extension filing an I-129, whether it's an L-1 and H-1, we would recommend filing it as early as possible and filing in premium processing if the employer is willing to do that. So that you can get the answer before your current visa expires, before the current I-94 expires.
Anything else, Emily, before we?
Nope, I think we're out of time today. Sorry we couldn't get to everyone's questions, but definitely stay tuned next week and every week. It's going to be a tumultuous 4 years here that we have to deal with. These memos and updates and things, it was constant. Every week we had something new to discuss during the prior Trump administration, and this is going to be the same again this time around. So stay tuned for updates on the registration requirement, updates on this NTA memo, and any